May it please the court, my name is Madison Lucey, and I, along with my co-counsel Emily Dreyfus, represent the appellee Olivia Benson. This case is about an employee who is trying to use his grievance and assert it as a constitutional issue. My co-counsel will be addressing issue 2 on how Benson could limit Curtis's speech under the Pickering balancing test. I will be addressing the first issue of how Curtis's speech is not protected because he spoke as a public employee on a matter of personal concern. We respectfully request that the court affirm the district court decision in granting Olivia Benson's summary judgment, but reverse that Curtis spoke as a citizen on a matter of public concern. Curtis spoke as an employee for 2 reasons. 1, he identified as an officer, and 2, it was part of his job duties. Curtis spoke on a personal concern for 3 reasons. 1, he spoke about his job duties and disputes in the workplace. 2, his speech was false. And 3, he didn't allow his allegations to internally unfold. Any of these 5 elements would render Curtis's speech unprotected because the Supreme Court of the United States held that the First Amendment protection for public employees is limited to only when an employee speaks both as a private citizen and on a matter of public concern. Connick at page 142. It's presumed that the employees working in their official capacity, overcoming that is more difficult for police officers because they have a higher standard. Would Your Honors like a brief recitation of the facts?
No, I believe that's okay. Thank you.
Thank you. Officers work in their official capacity when they either 1, merely identify as a police officer, or 2, serve as a community caretaker. Canigula. Courts examine the nature of the officer's job responsibilities, the speech, and the relationship between the 2. Curtis spoke as a public employee because he identified himself as an officer. And Curtis served as a community caretaker within his official job responsibilities because his speech was designed to prevent potential hazards from materializing and was performed to preserve and protect community safety.
Counselor, we consider some hypos related to that because you're defining his role very expansive.
It is.
Garcetti tells us that whether a public employee's speech falls within his or her official duties goes beyond the mere job description, right? But there has to be some relationship to their official duties. You say he's got a responsibility as a police officer to guard people against hazards, right?
Yes.
So if there's a soda spilled on the hallway in his apartment building, and he warns someone, "Hey, be careful, don't slip in that," right? Is that him performing his official duty as a police officer?
Would you consider it to be a hazard?
Well, sure, if someone could slip and injure themselves. Right, let's assume he's off duty. He's just in.
I would say yes, because Canigula v. Strom showed that a police officer operates in their official capacity as an employee when they act in any of an infinite variety of ways to attempt to preserve and protect community safety amid potential danger. It's become a catch-all for the wide range of responsibilities that a police officer performs outside of their criminal enforcement activities.
If we have concerns that that's a bit too expansive, is there a way to narrow that standard a little bit and still kind of satisfy your concerns here?
If we were to narrow it, I would say that, well, for one thing, Judge Chauvin, you asked that if he learned about the information in his official role, does that mean that he's working? You asked that to the opposing counsel, and I have a better answer. The nature of Curtis's speech was employment related, and this shows that he was working because he discussed departmental problems that created inefficiency, the lack of technology, and danger, the ill-fitting bulletproof vests. So his speech had a relationship to his ability to do his job effectively because he stated that the department's problem made his job more time-consuming and that he risked arresting the wrong suspect or responding to the wrong house. So that could be a more narrow way of defining trying to prevent and preserve protecting the safety of the community amid potential danger. Curtis served as a community caretaker because his speech was designed to prevent the potential hazards from materializing of the police department closing he was trying to preserve and protect the community's safety. His speech was personal because it concerned himself, not the public. It concerned himself because it involved a workplace dispute. It also involved his ability to perform his work duties, and his speech was knowingly false, and he didn't allow internal unfolding of allegations. To be a public concern, it must be political, social, or another concern to the community, such as being illegal conduct by public officials. Courts look to the content, form, and context of a given statement as revealed by the whole record. The Supreme Court construes protected speech by a public employee narrowly because they don't want every remark and every criticism of a public employee to plant the seed of a constitutional case. Curtis's speech was personal because he never alleged Chief Benson did unlawful acts. There was no mention of politics, social, or other concerns to the community, and therefore it was personal.
Counsel, wasn't there mention of the police department shutting down if they lose insurance or losing insurance generally? Wouldn't that be another concern to the public?
It would be if it was true, but that was false. Curtis's statements of the possible police department closure were false because he knew that Chief Benson has and continued to run the department successfully for many years. She told him that she was handling it, and actually she was ahead of schedule and only had one task remaining. So if it was accurate, then that would have been, but because his statement was false, she did 2/3 of the high priority tasks in half the time that was assigned. She still had 3 months remaining. And that leads me to the next point where it's personal because Curtis had unsubstantiated allegations and he rushed without it allowing to internally unfold. He rushed because 1 week after he didn't get what he wanted from Curtis, he ran to the city council rather than permitting Benson to have the remaining 3 months to complete her tasks. He spoke to the public on the unsubstantiated allegations of misconduct that didn't internally unfold, and that does not serve the public. It's held that officers risk eroding the public's trust when they go to the public with unsubstantiated allegations of abuse or misconduct without allowing internal review and investigations to unfold. Belani said that no one is served when officers rush to try their employers in the court of public opinion, and that makes Curtis's speech personal. Also, the content, form, and context of the whole record, that it was a workplace dispute, it involved his duties, it was knowingly false. It didn't allow the investigation to unfold when she had 3 more months to do so. That content, context, form, and circumstances surrounding his statement made it personal. The employees should not be allowed to assert their grievances as constitutional issues because doing so would render every remark of an employer to lead to a lawsuit. This is why the court should affirm Benson's summary judgment and reverse that Curtis spoke as a citizen on a matter of public concern. Thank you.